First thing is just adjust the mic. So first thing is just adjust the mic. So and you know what the time is. Your timer's on.
Good morning, court. My name is Ali Shakur, along with co-counsel Deborah Bell. I have the pleasure of representing James Colley Jr. This is an initial post-conviction case. Although we stand on all of the issues that we raised and pled and appealed and petitioned, today I plan on spending my time discussing cumulative penalty phase relief with a specific focus on issues 6 and 7. Mr. Colley sits on death row because of the prejudicial, undue influence the prosecutor called this judge to testify for the state.
Subpoena.
I can't recall if there's a subpoena or not, but he was compelled to testify for the state.
Judge presided over the same day of the murders in this case. The judge presided over a domestic violence injunction or something like that.
An injunction proceeding, yes, sir.
And your client pled guilty to that. It was a negotiated plea.
Correct, sir.
To a misdemeanor.
Correct.
And the judge conducted a plea colloquy.
The same morning, correct.
And now,
video was not very good quality. And Judge Moss mentioned that at the case management conference. The video was not of very good quality. So the state aimed to put this judge on the stand, Judge Charles Tidland, a county judge, to testify for the state in rebuttal to Mr. Colley's testimony and Mr. Colley's presentation regarding the fact that he was impaired at the time of the crimes. So the state put on a sitting courthouse judge, Judge Charles Tidland, with 28 years of experience on the bench in that same courthouse.
Right, but your argument isn't that a judge can never be called as a witness, is it?
No, we're not saying
and
that. And
your argument isn't that whether or not the judge can be called as a witness depends on how many years of service he has, right?
Not specifically, no.
Okay, so then focusing in on the point you're actually trying to make, and I'm following here Justice Labarga's question, it would seem to me like if the defendant has put in issue his competency or his state of mind or state of impairment that morning, the judge would seem to be a witness to his state of mind. What am I missing? Did he testify in a robe? Did he, tell me what indicia of credibility that are undue that the judge is testifying.
Judge.
So let's speculate that it would have been better if somehow testifies, don't call him judge or don't call her judge.
The error is calling the judge to testify.
But your client put into evidence the state of his impairment.
Right.
Right?
So,
they put that at issue.
Correct. And the state should have called another witness.
Well, okay, I understand that the state could have called someone else sitting in the courtroom, but that's not really the question before us. The question is whether the state cannot call this witness, who, like any other fact witness, was present, right? Had an observation of the defendant's demeanor and interaction with him. It would seem to me like he possesses relevant evidence. So then the question as an evidentiary matters becomes whether there are things that overwhelm the relevance of the testimony by making it prejudicial in some way. And I'm not hearing what specifically causes that in your argument. You've said it isn't. You're saying maybe it was the fact that he was referred to as judge. Is that what you're asking us to hold?
Well, it's not just that, the fact he was referred to as a judge, and there has to be a compelling need for a judge's testimony. Even the cases submitted by the state, and the state did do an answer brief in this case, and the state cited to a case called Rodriguez versus State. And in that case, Rodriguez wanted the trial judge, in Rodriguez, the trial judge actually testified in post-conviction. But there's a compelling need for the testimony. And the judge just testified regarding records. He didn't testify for or against one of the parties.
Well, the compelling need thing, it would be if there was no other evidence available to prove sobriety person. Example, if the only person who saw the defendant that particular day had been the judge, bumped into him walking to the courthouse, saw him at Kmart that morning, or judge's shop too, and
right.
That kind of thing, where the judge is the only one who saw him. But here, the state had plenty of alternatives. I mean, I conducted those hearings before as a trial judge,
right.
And when you do first appearances in the courthouse, I mean, there are a number of people around. There are deputies, there are police officers present who can come in and testify he was sober. There's court reporters. There's lots of people. You can even call someone in the state attorney's office who was present to testify. And using a judge to come in and testify and tell a jury, I'm a judge and I'm telling you he was sober. When there's a videotape and there are other witnesses that can testify to that, I mean, I can't think of anything more prejudicial. It's a factual matter whether he was sober or not. The jury can look at the tape and see if he was sober.
Correct, Justice Labarga. The jury can see whether or not he's sober.
But counsel, you did point out that there are questions about the quality of the tape, and the evaluation from this grainy tape is different than the evaluation of someone who was there, who had the responsibility to decide that he was competent to enter the guilty plea. Isn't that true? That's fundamentally different.
His trial attorney was sitting right next to him the whole time, Mr. Kyle Bedrins, and he had a duty to make sure that Mr. Colley was competent and not impaired to issue a guilty plea.
Well,
and Kyle,
but here's the reality. You don't contest that it could be admitted that a determination had been made that morning that he was competent to enter the plea, do you?
I think there needs to be an evidentiary hearing to make that determination. That's one of the things I'm asking for this court, to remand for an evidentiary hearing on this issue. We need an evidentiary hearing.
No, I'm talking about the historical fact of what happened at that hearing. You don't contest that was admissible.
I don't contest that it was admissible. It was not admissible through the testimony of a sitting
Okay, you
courthouse
contest
judge.
that it was admissible. What you're contesting is the way it came in. But it seems like to me, once it comes in, then this whole thing kind of dissolves into kind of quibbling over not much. Because if the historical fact that the judge at that hearing, that injunction hearing, had made that determination can come in, then whether you get the testimony directly from the I just don't see the prejudice in getting the testimony directly from the judge if it can come in that the determination was made.
Well, before I can even concede admissibility, we have to look at the context of this case. And in the context,
I thought you'd already conceded it. To me.
Well, I just conceded on the record, but we didn't raise a admissibility claim, so I want to stick to the context of the claims that we raised. So assuming it was admissible, and we're assuming that this information regarding impairment is admissible, then it needs to come in through another witness who's not prejudicial, who's not being called judge with 28 years of experience, who's not being cross-examined by his own trial counsel referring to, hey, Judge Tinlin that, Judge Tinlin this, in front of a jury. That's extremely prejudicial, when they could have called the same trial attorney, Kyle Bedrins, who testified in guilt phase. The guilt phase attorney could have testified to the exact same testimony.
Well, I mean, the problem is here, and I understand you're doing you've got to do the best you can with what you got, but the problem is these facts are highly prejudicial. I mean, he had this hearing where he seemed to be performing very well, but that's just what happened.
Yeah.
And it's inconsistent, it seems to be, or at least one could take the reasonable view that it's inconsistent with the story about that he's under some kind of state where he doesn't really know what he's doing when he's there demonstrating that he does know what he's doing. And so that's what's prejudicial here. Whether the judge is talking about it or not seems to me to be a matter of minor significance in the context of what the actual facts are. Now, I understand you don't agree with that, so tell me why I'm wrong about that.
Well, the defense made impairment an issue at trial. So in rebuttal, the state called a sitting courthouse judge, Judge Tinlin, to testify in rebuttal. They could have called, if impairment's an issue, then call the trial attorney, Kyle Bedrins, call the prosecutor, Josh Bird, who was there for the process. As Justice Labarga mentioned, other witnesses are there other than somebody using the influence and power of the judicial bench. And speaking of what Mr. Colley was going through, he wasn't just impaired with intoxicants. He's a poor metabolizer for a drug called Cymbalta. And that's claim 7 of our motion. The fact that Mr. Colley is a poor metabolizer for this drug, if the jury would have heard this information, it would have humanized Mr. Colley. Mr. Colley was doing everything he could to try to save his marriage. He was spiraling. He was crashing out. He was having so many mental health issues, substance abuse issues. He went to go see a doctor saying, hey, doctor, I need something for what I'm going through. The doctor prescribed Wellbutrin. Turns out Mr. Colley's also a poor metabolizer for Wellbutrin. But the switch from Wellbutrin to Cymbalta 17 days before the crime also exacerbated these issues. And that's also the reason Mr. Colley's sitting on death row today.
On this issue, I think that's all. Those are all facts that are part of the context of the case as it comes to us. But on this issue, this presents as a Strickland question, right? And so the question is, the prejudice that results to your client as a result of the judge's testimony and the lawyer's failure to object to it. And I guess what I'd like to hear is your argument that your client would have received a life sentence but for the judge's testimony, because I think that's a really tough road to hoe.
Our client would have received a life sentence but for the judge's testimony, because jurors are taught to believe and trust judges. Judges and justices wear robes. We stand up when they come in. The state mentioned in their answer, and I think the trial court might have mentioned, this is no different than a police officer testifying in a trial case. It's extremely different. Jurors watch TV shows, they live through life. They might have equivocal opinions regarding police officers, not when it comes to judges. And here in Florida, we have canons. The state cited to the canons in their answer brief. Canon 2A, the impartiality of the judiciary, the integrity and the impartiality of the judiciary.
Well, but is your argument that that Judge Tinlin violated the judicial canons by testifying when subpoenaed by the state or called by the state?
I'm not saying he violated the judicial canons. I'm saying this state treats judicial testimony extremely differently.
I understand, but I'm having a hard time understanding the relevance of the canons to the decision we have to make.
Because we also talk about the prestige of the judicial office, citing Canon 2B. So if we're treating judges differently when it comes to them testifying, like for somebody in a bar grievance, because they have this higher standard, then we need to keep that same analysis and that same energy for a capital case with somebody's life at stake. So judges are not just common witnesses. Case after case, in different contexts, this state treats judges as.
But this parade of horribles I'm not impressed with, because this is a pretty unique situation where the mental state of a defendant is related to crimes that happened later in the day. Was also at issue in a judicial proceeding that was conducted earlier in the day. That doesn't happen that often. I'm not saying it would never happen, but it's certainly, I don't see that if we decide this adversely to you, that means there's going to be a parade of judges testifying. This is a circumstance where the judge actually had to make a determination about the competency of the defendant. And that's what we have here, and that's different than other cases where somebody might just want to call a judge. The parade of horribles didn't impress me.
So if the judge makes a determination regarding the competency or the impairment of the defendant in front of him or her, that also goes to that judge's mental impressions. So I also like to also cite some supplemental authority that I plan on adding after this hearing. U.S. v. Morgan. Well,
you need to let people know about your supplemental authority before you come here talking about it.
Okay, I'll cite it, and the court can do with it what it will, but it just talks about exactly what we've been saying, the necessity regarding a judge testifying. U.S. v. Morgan, 313 U.S. 409. That's a 1941 case.
I don't think you heard me.
I heard you. Also, I will be doing a supplemental authority for U.S. v. Roth, which is cited as 333 for F sub second 565. Heightened scrutiny. So that's when the defendant wants the judge to testify. So we're still talking about heightened scrutiny, need, necessity, case after case, whether the state wants a judge to testify, the defendant wants a judge to testify, or a civil case. We need necessity, heightened levels of scrutiny, which we don't have in this case. But perhaps we might be able to get it if we were remanded for an evidentiary hearing. If we're going to do something in this state that allows a judge to testify in a capital case, something of such grave importance, I'd ask this court to remand for an evidentiary hearing so that we can see what trial counsel had time to do, or what trial counsel's strategy was, what their tactical decisions was. Something this grave, this important.
But none of that would be relevant to the prejudice issue, which it seems like a lot of the questions have been focused on that.
Well, prejudice is going to come out as part of the evidentiary hearing. Once there's an evidentiary hearing, we have to find out what the facts are.
No, I mean,
Why
you're
didn't-
talking about the facts that might go to the reasonableness of the sort of the first prong of the Strickland
Right.
test. But let's assume that the counsel should have objected to this. I mean, you'd still like what more would we know about prejudice if there were an additional proceeding on that?
If there's an additional proceeding, then we would know what trial counsel strategy was. And regarding prejudice, more would come out regarding prejudice as far as what Mr. Colley was going through, particularly the fact that he was improperly medicated with Cymbalta at the dosage that he could not metabolize. 3 experts testified to that.
So that's a separate issue, though, from the judge issue.
Right. Exactly.
And as to just to sort of close the loop on the judge thing, I mean, the prejudice would be have to, you know, it would be evaluated in light of everything else, you know, the aggravating factors, all of the other ways. I mean, I'm not really sure. Given the fact that obviously there was a full airing of all, you know, of your client's kind of perspective on his mental state and everything, you know, both the jury and the sentencer were able to consider all that, and they still made the decisions they did. So it seems hard to believe that this would tip the scales potentially sufficient to meet that prong.
It would tip the scales because we have a jury was there. And the jury heard a sitting judge say that he seemed okay to me. I stand here with the state. I'm paraphrasing, but by a judge testifying as a judge with 28 years of experience for the state in a capital case, just like a police officer.
Well, are you arguing that it's? It seems like you're almost arguing that it's structural error, but you really haven't argued that.
What was that, Judge?
You aren't arguing that it's. You have not argued that it's structural error, have you?
No, prejudice.
Okay. Okay, so you concede that we got to show prejudice, but then you are in effect arguing that if it's not structural error, it's close to structural error because just having a judge testify is such a devastating thing.
Well, this court needs a record to see exactly how devastating it is, so that's why you should remand for an evidentiary hearing to see what other witnesses could have testified.
What's devastating in this record, I think many people would say, is not. Has nothing to do with what the judge did. There are a lot of devastating things in this record that are not that.
Justice Kennedy, this is a capital case. All capital cases have heightened degrees of devastation, sadness, murder. That does not mean that Mr. Colley does not have rights under the United States Constitution to protect his liberty, interest, and his life. That's why I'm here today. But I'm well into my rebuttal time. Thank you.
May it please the court. My name is Naomi Nichols, and I represent the state in this case, the appellee. Amanda Colley was granted an injunction for protection against her estranged husband on August the 10th, 2015. A little bit over 2 weeks later, Mr. Colley, in the wee hours of the morning before sunrise, decided to go to her home. He wasn't there. What he found instead was some evidence that she was having a relationship with another man. He ransacked the home and left. Later that morning, he drove himself to court and entered a counseled plea, which was recorded, and the jury saw that video. He then drove himself, after making several stops, back to Amanda's home. By that time, she had 3 friends over: Lamar Dauberly, Lindy Dobbins, and Rachel Hendricks. James Colley concealed his vehicle and approached the home after arming himself from the back. When he saw people inside, he then opened fire through the back sliding glass doors. The occupants of the house fled when they heard the gunshots. Lamar Dauberly ran out and escaped through the garage.
I'm sorry to interrupt you. Could you please just respond on this?
Yes.
Just kind of pick up where he left off and talk about the arguments that he made.
The bottom line is that the defense cannot show prejudice with the Judge Tinlin testimony. Dr. Danziger also testified in rebuttal, and he testified about having reviewed deposition transcripts from the judge and from Kyle Bedrin, the defense attorney who represented Mr. Colley at that plea, who testified for the defense during the guilt phase, that he had no concerns about Mr. Colley's competence to enter the plea at that time. He testified that he seemed a little more agitated than usual, but he had no concerns about his...
Going back to the prejudice aspects that's been raised here. I've been on this court now for going on 17 years, and I think I've seen just about everything. And I've seen murder cases that was just so atrocious. And you sit back and think, there's no way a reasonable jury would not recommend death in such a case. I'm talking about burying people alive, things like that. There's just no way. And you look at it, it's like 7-5. So this whole business about Monday morning quarterbacking what juries would do and us decide there's no reasonable jury that would not, recommend death is silly. And because it happens all the time. And we started getting unanimous decisions back when we required it during a period of time. But now, before it was unanimous, we used to get those kind of, usually 2, 3, 4, pretty close sometimes, jurors, in cases that you would think there's just no way. If you're going to have a death penalty, this case is a poster child. Yet they come back with 7-5. So how can we sit here and pretty much conclude that a jury would not ever be influenced by a judge testifying?
The standard that the court cited in Strickland was that the court is to presume that the judge and the jury followed the law. And the jury was instructed in this case to weigh the credibility of witnesses. One difference about in the judicial canons, it talks about judges giving testimony, or they should not give testimony in cases where they're testifying about the credibility of another person. But that's not what happened in this case. He explained his role, Judge Tinlin, and he explained that he would not accept a plea if he had any indication that someone was under the influence. And in this case, Mr. Coley told him that he was not under the influence of any substances.
But the thing is, see, here's my concern. This is Supreme Court of the state of Florida. And we're going to write an opinion that says it's okay for a judge to come in and testify and be identified in front of the jury as a judge. Have the judge testify as to a factual matter in a case to be decided by the jury. We're going to open up that floodgate. And in every case, and from now on, not every case, but in many cases, I suspect, you're going to have we making it okay for a judge to be called in any case involving mental health issues. Mental health issues. I mean, judge coming, let's say in the guilt phase, insanity defense. Well, he was before me that day that he killed him. He seemed fine to me. He understood everything. See, from now on, prosecutors will get a green light to just start calling judges as witnesses in these mental health issues.
I hear your concern. I believe this case, it's very factually specific, and I can't imagine that there are going to be many cases where a defendant was in front of a judge the same day that they then committed a crime, and the judge, when mental health is brought into the defense, the judge would then need to testify. So it's very narrow, and it's in any case.
Can you address, though, so you started off, though, focusing on prejudice, which wouldn't require the court to kind of affirmatively say, as the question assumed, that we would say, oh, this is okay, quote unquote. What's your position on whether, putting aside, we know obviously what your position on prejudice is, but is your position that, that it is quote unquote okay, that this, should the state should there have to be some kind of, kind of particular need for this? I mean, what's the, are you just sort of going along with the idea that we would just kind of affirmatively say, hey, just pick anyone, judge, whoever?
I believe that there is no case law that says that a judge is incompetent to testify, and if you decide this and you put some limitation, that's going to be a new thing. I couldn't find any case law that says anything other than a judge is a competent witness, but should limit their testimony in cases where credibility not credibility, but you don't want them to be supporting the person they're testifying about.
But you see, that's the thing. It's once the decision is made that a judge is competent to testify in a trial, what limitations can we put on that?
The decision is made. Judges are competent to testify.
Right.
That has been held.
So what limitations can we put on a judge that's not? How do you decide which time a judge can testify and which time a judge cannot testify?
Well,
how do we decide that?
The judicial canons are there already, so something in line with those would seem appropriate.
And what did, in this case, I mean, what did having the judge specifically testify about this add to just sort of the historical fact that there was the hearing and that the judge at the time had made the finding that Mr. Colley was mentally competent to enter the plea? I mean, what was sort of the value add beyond that? Because really, that's the judge. I mean, the judge isn't getting up there testifying about how people metabolize medications, and he couldn't really say what was in the defendant's mind at the time of the actual shooting. I mean, he's really only there to talk about, this is the hearing that we had, and this is my perception of his mental state at the time. That's pretty much it, right?
Yes, I think.
And so what's the value add then of having him testify on top of that?
To explain to a jury what one of the judge's roles is in a plea colloquy. So if they're just presented with this video and they didn't have an explanation of, a defendant comes in there, they're asked certain questions, and the judge's role is to determine whether or not he can accept a plea from them, if they're in a mental state that he can legally accept that. And so it was just an explanation, I think, for them of that type of hearing and what a court's role is, which they wouldn't have gotten from anyone else.
But that's kind of almost sort of an academic kind of point. I mean, in hindsight, is that something that, should the state have used someone else to, if you thought the jury needed, or whoever the decision maker is, needs to understand that? I mean, you don't really need the specific judge to come in and talk about that.
Well, the state's position is that the defense can't show prejudice in this case, because even if the judge didn't testify, the overwhelming aggravation and the testimony from Dr. Danziger specifically about reviewing the plea colloquy, and in his opinion, the defendant was not suffering from an Arabian parasomnia and seemed to be in a competent mental state on his review of the video. So even without the judge's testimony, there can be no prejudice.
Can we talk about McCoy versus Louisiana for a little bit?
Sure.
So I want to understand the state's position. Obviously, McCoy is a different case because the defendant there denies committing the act altogether. Here, the defendant doesn't deny pulling the trigger over and over again. The defendant denies a different element of the crime of conviction, and that has to do with his mental state. And his position is he thinks this is a manslaughter trial, and he asserts that he would not have taken the position he took on that element, on the element of the requisite mens rea for the crime or the other elements of first-degree murder. Is the state's position that a defendant has a constitutional right only to deny, under McCoy, the act element of the crime? Because it would seem to me like if the defendant had a constitutional right to deny that element, the defendant would have a constitutional right to deny any element of the crime of conviction. Help me understand what the state's position is on McCoy versus Louisiana.
So, first of all, the big difference is that McCoy himself raised this issue before trial started. He was unhappy with his defense attorney's plan of arguing a lesser included. He made that known to the trial court. He asked for a new attorney, and the trial court denied it. And then after trial, when he was convicted, he then got a new attorney, and that attorney filed a motion for a new trial based on this issue. And that was appealed in the direct appeal. And so when the Supreme Court made the decision in McCoy, they're working off of those facts. So here, there was nothing on the record about what he wanted other than he was happy with his defense's strategy. He says that before trial.
He does affirmatively suggest that, yes.
Several times. And the Supreme Court talked about the objective of the defense. And the trial court found that trial counsel did comply with the defendant's objective of the defense. They found that he was told that they discussed it, and this is on the record too.
Yeah, but I'm not hearing an answer to my question, though, which is, does McCoy give me, a defendant, the right to instruct my lawyers and insist on each element of proof, or is it just the actus reus? Once I've admitted to pulling the trigger, does McCoy not protect me anymore? That's the question.
I don't think it does.
Okay.
I don't think it does. I think you have to. Attorneys still need to be able to make strategic decisions and how they represent a client.
So what's special about the act? So what is special about the act element of the crime? Like, what makes that different than the other elements of the crime?
In McCoy, the court addressed he wasn't guilty at all of any of the elements. So it's all of them together. I don't think we can pull out one, even if it's the mens rea or the actus rea. I don't think we can pull out one and say, well, let's broaden McCoy now and apply it just to that.
The McCoy rule applies if, but only if, the defendant denies all elements of the crime of conviction. That's the state's position.
Yes, they want to pursue a not guilty verdict, that they are not guilty of anything.
They're always trying to pursue a not guilty verdict, right? Like, if I'm charged with lesser included offenses, I'm obviously trying to pursue a not guilty verdict as to the top line offense, but perhaps I'm willing to, eat a lesser included. So what you're saying is McCoy only works when the defendant says, as to the top line and all the way down, I deny all of it.
And with an express objection on the record at trial.
Okay.
Well, and isn't that actually, there are things that are said in McCoy that support that understanding of McCoy, specifically the court, and talking about the cases that it believes are aligned with the way it's deciding here. It says these were not strategic disputes about whether to concede an element of a charged offense. They were intractable disagreements about the fundamental objective of the defendant's representation, which is this guy, he wanted to say, I did not do this. I did not do these physical acts. And the lawyer in McCoy was not comfortable with that, and we got this case. We got the McCoy case. But that's just different than what we have here, where it's where there's no dispute that the defendant committed the physical acts. It's just he thought that it could be characterized as an accident, and that he could be found guilty of manslaughter. Isn't that what's going on here?
Yes.
Which is entirely different than what was going on. So what we do have here is a strategic matter about whether to concede a particular element.
That's correct. And the trial court found Coley did testify at the evidentiary hearing, and so did the trial counsel, that this was discussed. This was not something that they pulled out of their pocket without him knowing. It was discussed beforehand. They told him that he would never get manslaughter, that it wasn't going to happen.
But it's clear he didn't like that, right?
He didn't like that. He didn't like that.
But we would only need to get to this kind of level of sort of dissecting McCoy if we accepted the premise that there was kind of a clear statement by the defendant to the lawyer, look, I am willing to, concede manslaughter, but not second-degree murder or anything more than that. Because you could imagine a different case where, you have a sophisticated defendant or whatever, and they get into these kind of fine-grained conversations with their lawyer, and there's no dispute that the client communicated, I will, agree to this, but not to that. Are you putting this case into that category, or would you say that it hasn't even really been established what exactly it is that that Colley kind of agreed to or didn't agree to?
It's not in that category. I don't think it can be, because it wasn't raised in the trial court. The judge engaged with a colloquy with Colley before trial, and when the state rested,
okay, but
again,
how about just based on the record that we have now in post-conviction?
Right,
because
no.
that's kind of another variable, is the objection thing.
Now he's saying that that's the only thing he wanted. We haven't established. I think It's important that
What did
McCoy
did
was
the trial court make a finding on that here, though?
on which part?
On what exactly it was that Colley agreed to with his legal team or didn't agree to?
She found that he agreed, and they pursued a lesser included offense, which is what he wanted.
So nothing.
I don't think she
wasn't-
made a specific finding on whether or not he agreed to manslaughter.
Or I guess really the right question would be, did he specifically kind of tell them don't? You know, did he clearly communicate to them, I do not want you conceding second-degree murder?
Right, that didn't come across.
When was it? When was the statement made? During an opening statement? Is that where?
Conceding
Yeah,
the second degree in opening statement.
an opening statement.
Yes, and in
I
closing.
take it also in closing statement.
Yes, yes. They argued manslaughter, but that was directed at the attempted murder counts.
Okay. That's okay.
If there's nothing further, the state would ask that this court affirm the
Well, let me-
lower court.
Just
Yes,
one
sir.
question, and I don't want to be nitpicked, but I will be. On the question of the rule of sequestration,
The
the rule of
rules.
sequestration, the state requested and was granted to allow the lead detective, in this case, Detective English, I think it was,
Yes, sir.
to sit next to the prosecutor throughout the entire trial. Rule 90.616 provides that exemptions to the rule of sequestration, and one of them being that it is essential and necessary for that lead detective to sit next to the prosecutor throughout the whole table, listen to the entire testimony, and then testify. What was it about this case that was so complicated that it required a lead detective to sit next to the prosecutor? I've tried hundreds and hundreds of cases. I've presided over, and I've never seen a judge testify in 45 years, and I've never seen a lead detective sitting next to the prosecutor. What was so complicated about this case that I was allowed?
I can't answer that specific question because it wasn't me, but there were a lot of timelines and there were a lot of videos. There was a lot of evidence in the case, and what I understand from the record is
all
that
cases have that. I mean, cases that last weeks and weeks with tons of testimony.
so this motion in limine was raised prior to trial. The defense didn't object to it, and so we have to consider now whether that was deficient and whether there was any prejudice from that decision not to
Here we
object
go again,
to
the
it.
prejudice.
Right. And her testimony ultimately was not. She entered in evidence. There's no confrontation really issue with her testimony.
Okay, I was just wondering what was different about this case than all the other ones where we don't have a lead detective sitting throughout the entire trial.
I don't have a great answer for that. If there's no further questions, the state would ask that the court would affirm the lower court's denial of relief in this case. Thank you.
Thank you.
Thank you. Carry on from what Justice Labarga was discussing regarding on what was different about this case and Detective English. Well, one thing that was different was the fact that Mr. Shoemaker's law firm was representing Detective English's agency as an act of conflict of interest. They were general counsel for
What rule
his.
does that violate?
What rule does it violate?
Yeah, what rule? What specific rule did that violate?
Well, it's cited.
I'll tell you to cite chapter and verse because that's been discussed.
Well, Judge, I'm not here for a pop quiz, but I can tell you cited in our brief.
Oh, you're not? You're not here to answer questions?
I am, but I can't tell you off the
Okay.
top of my head, Judge, but it's cited in our brief, you know. And in answering more questions, I can tell you that regarding prejudice in Judge Tinlin, more prejudice regards the fact that Judge Tinlin's testimony made it right directly into Judge Maltz's sentencing order, and he gave it great weight. So I'd urge this court to remand for an evidentiary hearing to also hear testimony regarding the relationship between Judge Tinlin and Judge Maltz, because we mentioned that witnesses saw them having lunch together on the day of Judge Tinlin's testimony. And one more thing regarding the issue of McCoy and manslaughter. Trial counsel was on notice before trial that Mr. Colley determined regarding this as a manslaughter case and strictly a manslaughter case, nothing more than that. So that's on the record. That's on the record before this court. Mr. Colley told his trial counsel, this is a manslaughter case, nothing more. Whether trial counsel disagree with that, that's not trial counsel's right. Their job is to pursue the trial litigation strategy of their defendant, and they did not do that in this case. Beyond that, I believe I'm well into my rebuttal. I would ask you to reverse. I'd ask you to remand for an evidentiary hearing on issue 6 and all the other issues that were denied in evidentiary hearing. This is a very complicated and stressful case involving adultery and a person who was spiraling out of control because his marriage was falling apart. This is not a case involving the most aggravated and least mitigated of our citizens. I'd ask you to reverse and grant Mr. Colley a new trial. Thank you for your time.
Okay, thank you. We're adjourned.
All rise.